I'm not
To
objecting to that.
hours.
I don't see
Yes.
how that's relevant for
Mr.
this either.
Sandfield, come on.
Judge, I'm trying to just show you that there's no
I
contact.
can show you text messages over the
Stop.
course of our
No,
5-year
stop.
relationship saying
Stop.
that. Sorry.
Hey, nobody gets to talk when I say stop. State of Michigan versus Ryan Schultz, file 25-43974-SM. Set for a motion hearing today.
Judge,
There-
I just wanted to know, it looks like we have the Crawford County courtroom here. I don't know.
All
Any
right,
event,
we're here
Judge,
on the Schultz matter. There are competing motions to either revoke bond or to set aside the no contact provision of the bond. I'm going to let the prosecution go first as to their motion. Then Mr. Sandfield, you can go first, next as to your motion. Ms. Brucker, do you have any opening statements that you want to make, or do you want to just get to the testimony?
No, Your Honor, I just wanted to make sure everyone has, I sent out before the last hearing some exhibits. So we're all following along together. I want to make sure everyone has them. I set out one that was labeled Exhibit 1 and consists of 2 pages. Another one labeled Exhibit 2 and has a number of pages of text messages. The last one, I don't think I put a number on, but there's a People's Exhibit sticker and it has some photographs on it.
Judge, I don't know if I put my name on the record, by the way. Good afternoon, Judge. My name is Gary Sandfield, counsel on behalf of the defendant.
Thank you, Mr. Sandfield. My apologies for not letting you put your appearance on the record. I do have those documents, Ms. Brucker.
Okay.
Mr. Sandfield, I have those exhibits, I believe, from you, at least we're connected to your, I have a long list of, looks like screenshots of Facebook and along those lines. So I have those as well attached to your response to the people's emergency motion to revoke bond. Is there any other documentation that I should have, counsel?
Not in front of you, Your Honor. I have a couple of recordings that I'll play, but as far as printed documents, that's all I have.
We don't have anything additional. Well, I can't think of anything additional at this moment.
All right, Ms. Brucker, do you wish to proceed, or would you proceed at this time, please?
Yes, Your Honor.
Judge,
I call.
before Ms. Brucker, may I make a brief statement regarding where we're at on this today before we move forward on this bond violation?
If you feel you must.
Well, what happened, Judge, is it's my understanding that the complaining witness does not really want to pursue the bond violation, but rather is being encouraged to do so by maybe an overambitious prosecutor and or crime victim.
Mr. Sandfield, I find that to be totally useless argument.
Okay.
Whether the prosecutor is ambitious or not, she has the right to bring whatever she wants to do in a criminal case. So your whining about it isn't going to do anybody any good.
All right. Sorry about
So
that.
you got anything else that you want to bring to my attention?
Not at this moment. Thank you.
Thank you. Ms. Brucker, please proceed.
Your Honor, my first witness is Sarah Mirror, and she is here on the Zoom. I'd ask the court to swear her in.
Ms. Mayor, would you raise your right hand, please, so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Thank you very much. Ms. Brucker, your witness.
Ma'am, could you just say your name for the record and spell your last name?
Sarah Mehrer, Mehrer.
And do you know someone named Ryan Schultz?
Yes.
And how do you know him?
We've had a 5-year relationship and we share a child.
And you are a witness and victim in this domestic violence case that's pending, correct?
Correct.
Okay. And we're not going to get into the substance of that case today, but we're going to talk about the bond right now. I wanted to direct your attention specifically to January 29th. Do you recall that date?
I do.
Okay. We have a court hearing that date
Yes.
that you recall? Okay. After that court hearing, Ryan Schultz have some contact with you?
Yes.
And can you describe what that contact was?
Was upset about his lawyer asking to postpone everything just because you weren't there and to lift the no contact. And then texted him and said to not call me or text me. And then he did continue texting me and calling me.
Okay. So he sent some text messages on January 29th and after January 29th?
Right. Yeah.
Sorry, I couldn't, it kind of broke up. I couldn't
Ms.
understand.
Bruker, could you repeat that question? Because did not come through clearly.
Okay, I'm sorry. So he received some of those communications from him on January 29th and after January 29th.
Yes.
Okay. Did he also leave you any messages on your phone after that date or on that date?
Yes.
And what type of messages did you receive from him? Are these text messages or voicemails? Could you describe?
I got both, and they were mostly just begging me to talk to him, give him another chance, stuff like that.
Okay. Can I have you look at some documents? Did you provide some documents to our office and some recordings to our office?
Yes.
Okay. Do you have in front of you a stack of messages that's labeled People's Exhibit 2?
Yes.
Okay. So I'm going to just scrolling through those. Are those messages that you provided to our office that were exchanged between you and Ryan?
Yes.
Okay. Judge, I'm going to ask the court to admit that exhibit, then I'm going to have her go through them and explain what it is.
Mr. Sandfield, any objection to People's Exhibit 2?
I would defer to your discretion, Judge.
I'm sorry, I did not hear what you said.
Our objection would be obviously the documents. I mean, there hasn't been a real good foundation for them. I mean, it's a thick exhibit, but I would rather she went through them first and then move to admit before and had more of a foundation, as opposed to saying, I have these proposed exhibits, I want to admit them, then go through them.
Ms. Bruker, you opposed to that?
I can do that, Judge. Since it's a bond hearing, I was kind of trying to go through this a little quicker than we would if we were in a jury trial or something like that, but we can do that way as well.
Thank you. Please go ahead.
Okay, Ms. Mayor, I'm looking at the first page, People's Exhibit 2. There's a document. It shows the name Ryan Schultz at the top, and it says requested your location. Can you describe what that is and why you provided to us?
So he sent me his location and requested mine, and then he was having DoorDash come to the house and then asking to give him another chance.
So that's something sent you through your phone, the requesting your location?
Yes.
And why did he do that? Do you know?
Just to know where I was at.
Okay. Just going back for a moment, was there a time when the two of you resided together?
Yes.
Okay.
Up
And was
until
that
mid-December.
that was here in Otsego County?
Correct.
And then since December, you've moved to a different location?
Yes.
And where is that? Without, you don't have to give the address, but just say the general
Heartland.
location. Okay.
Livingston County.
Okay. So did you receive this message where he's requesting your location? Was that sometime after January 29th?
Yes.
Okay. And that was when you were living in Heartland, not in Gaylord?
Correct.
Okay. And then so he sent these other where the text is in the black, those are messages from him to you?
Yes, that's right. Okay.
And then going to the second page of that, and I'm sorry, it's labeled page 3, but it's the second page of that exhibit. There's a blue text bubble at the top. Is that something that you wrote?
That's what I wrote immediately after the court hearing.
Okay. And then below that, there are some messages in black. Are those messages you received from him?
Yes.
Okay. And it looks like there are 8 of them. Would you agree?
Yes.
Okay. Going on to page 4, there's some more text that's in black. Are those also messages that you received from him?
Yes.
And then there's a photograph of a dog. Is that something you sent him or something he sent you?
He sent that to me.
And then the text below, is that something he sent you as well?
Yes, it is.
Okay. And page 5 looks like continuation of that particular text, just with some additional text in the text stream. Do you agree with that?
Yes.
Okay. Page 6, there's some additional text at the top, starting with, can you stop doing this, please? Are those texts from Ryan to you?
Yes.
Okay. And then it looks like there's a video that was sent to you. Is that something he sent you as well?
Yes.
And then the text below it is also from him?
Yes.
Okay. Page 7 looks like a continuation of those text messages from page 6. Would you?
Yes.
And those are all from Ryan to you?
Correct.
Okay. And then page 8, one moment. There's some additional text in the black. Those are from Ryan sent to you?
Yes.
And on all of these pages that we've gone through, next to the text message, there's a time next to it. Is that the
Mhm.
timestamp for the time that you would have received those text messages?
Yes, it is.
Okay. And then looking at page 9, at the top, the name of it says Lana. Who is that?
That's Ryan's.
Okay. And then there's some text messages in black. Were those text messages that you received from his sister?
Yes.
And do you see the top one says Ryan colon, and then there's some information. Um, how did you take, what did you think that meant, receiving that from her?
She was passing along what Ryan wanted her to tell me to see if I would respond.
Okay. And it looks like some of the messages are about your child, but some of them are about other things. Would you agree with that?
Yes.
Okay. There's some blue text on there. Are those messages that you sent back to her?
Yes.
Okay. And page 10 also just looks like a continuation. Would you agree of some of those text
Yes.
messages? And at the bottom, there's another text that starts with Ryan and a colon as well. Do you agree with that?
Yes.
Okay. And then just looking at 11, would you tell us what that is, what the significance of that is?
That's my call log, just showing the repetitive missed calls.
Okay. So where it says Ryan, their time, and it's in red, those are times that he called you?
Correct.
Okay. And the timestamps next to it would correspond with the times that you received those calls?
Yes.
Do you happen to know what date you received those calls? If that was after January 29th or before?
Those were after.
Okay. And on any of those calls that he sent you, did he leave voicemails?
He did.
Okay. And did you forward those to our office as well?
I did.
Okay. Judge, I'd like to play for the court a few of the voicemails that she sent us. And I'm sorry, let me go back. I'd move for admission of People's Exhibit 2.
Counsel, objection? I'm sorry, Mr. Sandfeld, you're on mute
Could I just voir dire her real quickly?
briefly.
Ma'am, are those text messages that you just referred to, are those true and accurate of what you received from Ryan?
Yes.
Okay. And are there any text messages in that package also that you sent to him?
Yes. The ones that I confirmed.
Okay. And also, now this package, there were other text messages within this package that you submitted on those dates in question. You just didn't submit them as part of this exhibit. Is that correct?
I'm not
Judge, could you rephrase
sure
that?
what
Could
you're
you have him
saying.
rephrase that? I'm not sure she understands.
Let
I
me-
know
let
what
me
he's
try-
asking her. I'm not sure she understands what he's asking her.
Let me try to rephrase it. You're submitting these on these dates and questions that are on those messages, but you're not stating that there were dates within that time frame that you communicated with Ryan. They're just not attached to this exhibit. Is that true?
No, everything that I had sent when I sent them was the full amount of communication both ways.
Okay, so there you didn't delete anything that where you might have requested him to come over or to contact you. You didn't delete anything like that?
Correct.
And did you delete anything from his cell phone that were text messages that you sent to Ryan, but then at some time you got rid of his cell phone and deleted those text messages? Is that true?
I think I'm going to object to that question because it's a multi-part question. I think it's beyond the scope of voir diring this particular exhibit.
Well, it could be, Judge, if we're gonna say this is accurate and that he has all these communications, if this time it's not really fair to admit this document if it's not complete and if there were other communications, but this witness took an opportunity to erase those so that my client was devoid of the opportunity to present those items.
Certainly let you explore that on cross-examination. I don't know that it goes to it might go to the document, but it does not go to the admissibility of the document.
Okay, very well.
Anything else you want to voir dire on?
No, Judge, thank you.
All right, Ms. Brucker, are you renewing your request to have this document admitted, exhibit
Yeah.
number 2?
Yes, Your Honor.
Right. Exhibit 2 will be admitted. Any other evidence that you want us to adduce, Ms. Brucker?
Just a few other things. I'd like to play for the court a few of the voice messages that she received during that time period.
Any objection, Mr. Sandfield?
I haven't heard them yet, but I'm assuming that as long as they're accurate, we don't have an objection. I mean, I haven't heard what they are, so it's tough for me to say if I can object or not.
I think we sent them to you, or we at least made you aware that they're.
Ms. Bruker, if you could have the witness identify what you're in general, where it came from, when they were made, who's on them, that sort of thing.
Okay. Yeah, doing this over Zoom's a little more difficult than we would do these in person. Miss Mary, you sent us a number of voicemails, correct?
Yes, I did.
And do you recall approximately when you sent those to us?
I'm looking right now. January 31st.
And do you recall when you received those voicemails?
They were from January 31st.
Okay. Were there 4 of them?
Yes.
Okay. So those were all what you would receive January 31st then?
Yes.
Okay. Judge, I'd like to publish those for the court.
Who are they from, please, ma'am?
They were from Ryan to myself on
And
my cell phone.
Are those the only 2 persons that are recorded on those messages?
Yes.
All right.
And
Mr.
I'll ask
Sandfield
her-
now?
I was
Sorry.
gonna ask her one more question. And
Go
how do you
ahead.
know those voicemails were from Ryan?
They came from his number.
Okay.
And I mean, I know his voice.
Okay.
Now, Mr. Sandfield, do you have any objection?
Yeah, not at this time. I might want them after they come in. Also, Judge, I know this is somewhat informal, but I was just asked that the prosecutor try to refrain from asking every question as a leading question.
All right. You may go ahead and play the voicemail messages, Ms. Bruker.
Okay.
Sarah,
Can you hear that? That wasn't working.
I feel like I'm just annoying the out of you now. Please talk to me. Please. Please talk to me. I can't do this. Can't do this. Can't do this without you. Cannot do this without you. I cannot. I love you. Please don't make me do this without you. Please. Please. I love you so damn much. I literally cannot be without you. I don't give a fuck. Nothing matters. I don't want to be anywhere in this world without you or without the girls. Please. Please, please, please. Let me get through this with you. Please. Please, Sarah. I love you. Please talk to me. Please. I love you. I miss you so damn much. Please, Sarah. All I want is you. I want to make you happy. I want to, like, please. Please.
Miss Mayor, were the other 3 voicemails you received pretty similar to that as far as the contents of them, as far as you recall?
I would assume so. I don't really remember, but
Okay.
I'm
sure
gonna
they were all
object-
along
I'm
those
gonna
lines.
object to that question, Judge. You can't ask a question like for something that's not admitted into evidence. Is that the other stuff the same? If
Well,
she-
I was trying to expedite so I don't have to play
it's
all
better
4
play
of them,
them.
but I can do that if that's what's.
I'm not
needed.
asking I'm not asking that they be played. I'm just asking that you can't ask her a question about something that's not admitted into evidence and saying, is that accurate?
Mr. Sandfield, the rules of evidence at a bond hearing don't apply. So I'm trying to give you the benefit of the doubt, but it's 20 minutes to 4. We've been at this for 20 minutes. I think I understand where we're going with this.
Okay.
So let's just get it through it.
All right, I understand, Judge. Thank you.
Moving on quickly, there's another exhibit. It's marked People's Exhibit 1, and it looks like a map. Could you pull that up and look at that? And tell me you have that in front of you.
Yes. Okay, I do.
Okay. Is that something that you provided, those 2 pages attached to that exhibit? Is that something you provided to the prosecutor's office?
Yes, it is.
And why did you provide that? Can you tell me what it is, I guess, first? Describe what that is.
So the blue dot is myself at my new residence, and then the other little gray circle with a person is Ryan, parked down the road from my house,
Okay.
just camping out when I was telling him not to.
The second page, is that just a zoomed in version of the first page?
Yes.
Okay. You said camping out when you were telling him not to. Can you elaborate on what that means?
He was sleeping in his car in a park multiple days in a row.
That proximity from where you live now?
Correct.
And he does not live at that residence where you live now, and he never has?
No.
Is that like a screenshot that you grabbed from Find My iPhone or something like that? Or how did you get this?
He has periodically sent me his location and then unsent it, trying to get a response. And when he sent it at one point in time, I took a screenshot of it before
Okay.
it was unsent again.
So this is that screenshot that you took.
Correct.
Do you recall when the date of this was?
I
Was it
don't,
after,
but I
was it after
can.
January
It was,
29th?
yes, it was.
Okay. And there's a last exhibit. It's not late. I'm sorry, Judge, I'm going to move for admission of that exhibit, exhibit 1.
Objection, Mr. Sandfield?
Judge, I would defer your discretion as to the weight. Obviously, it's probably admissible, but I'd leave the weight up to you, up to the court.
Exhibit 1, both pages are admitted.
Moving on, Miss Mary, to the last exhibit. It's not labeled, but it's 2 photographs. I'm going to call it, I'm sorry, it's a number of photographs. I'm going to call it exhibit 3. Could you pull up that in front of you?
Is that one that,
It has that picture of a vehicle and there's a timestamp in the bottom corner. It's a dark picture.
oh,
You have that in front of you. Otherwise, I can screen share.
could you screen share it?
Yes.
Thank you.
Do you recognize that picture?
I actually wasn't sure what that one was.
So we'll move on from that. I'm going to move to
That's the one from the camera.
I'm going to mark that picture as exhibit 3. You recognize that picture. Could you tell me what is in this picture, what it's depicting?
It was Ryan parked at the house in Gaylord.
And why did you send that picture to us?
He was not supposed to be going back to the house yet. I had still not gotten all of my things moved out of there, and he had called and asked the police if he was allowed to go there, and they told him he would have to get permission from the court to do so, which he didn't do. And then when he wasn't getting a response from me, he went there and like broke his way in, to knowing I would see it on the camera, hoping that I would respond.
And so when was this picture taken? Was it prior to you moving to Heartland, or?
She already
Well-
said, Judge, that she'd already moved, but she had some things left in the house.
Well, I was
Ms.
still
Bruker gets
in
to ask the
between
question.
both.
So hang on. Ms. Bruker gets to ask her question. The witness gets to answer. Go ahead. Give me when it was taken.
It was after January 29th.
Okay. Is there some kind of like a surveillance or a ring camera that took that photo?
Yes.
Okay. Is that a screenshot of it?
Yes, it is.
Okay. Next picture, can you tell me what that is? Is that another one where you weren't sure what it was?
There's nothing
I
on my
don't know what
screen.
that is.
My screen's just a black square.
Okay. We already did that one. I will stop sharing. I'll move for admission of exhibit 3, just that one photograph.
No,
All right. Exhibit 3 is admitted.
I just have a couple of other last questions for you. Ms. Mara, has Ryan essentially continually had contact with you by text message throughout the duration of this case?
I'm going to
Yeah.
object to that. That's overbroad. And also, motion to revoke bond has got specific dates in it. And also, Judge, there was a previous motion to revoke bond, and that motion was dismissed, and that had dates in it. So to paint with broad strokes like that would be overbroad and inappropriate.
I don't know that a bond motion, other than giving notice, has to be specific as to the dates upon which each particular incident occurred. Can you cite me some authority for that, Mr. Sandfield?
Obviously, I don't have that at my fingertips, but I just know that we have a right to know what the issues are so we can prepare for the hearing. And the issues were identified in plaintiff's motion stating on certain dates and times certain activities occurred. And now to go back to, I think this case starts in July, is not really putting us on notice of what's an issue since July. But more importantly, Judge, until this hearing, bond motion before that, which had all these dates in it, was dismissed. So it was so that those dates really don't seem to be an issue on this motion.
If
There was no determination of the basis of the previous motion. Bond motion, the prosecution has made now, entitled its emergency motion to revoke bond, talks about of 26 over the weekend in January to early February of 26, and then also October of 25, September of 25. So it clearly is for a number of months worth of period of time. I find no objection there. You may continue, Ms. Bruker.
was there a prior time, Mayor, that you had made a report of a bond violation to the sheriff's, Otsego County Sheriff's Department while you were still living in Gaylord?
Yes.
And can you describe what you believe what the bond violation was?
Was the ones from September. And then I believe the other ones were December.
One in December, would you describe when you reported that to the sheriff's department and they took a report on it? Would you just describe what happened?
Was at the house. He had been there for multiple days, and then I was telling him I wanted him to leave, and he was swearing at me, calling me a bunch of names, and I said that I was going to call you if he didn't leave, and he finally did leave, and he got pulled over right outside the driveway and told the cops that he was just there to drop off or pick up our daughter, and then ended up letting him go.
Okay. You're having some difficulty, I know, remembering some of the dates. Is that because he's been continually having contact with you throughout this case?
Yes.
Okay. Has there been a time during this case when there's been any period greater than a day or so when he's not had contact with you?
No.
Okay. Generally, is the contact that he's been having with you since, and I'm just narrowing it to January 29th because I think that's a good benchmarker. Has it generally been over text message and phone call?
Yes.
Okay. Has he been to the residence at Heartland where you live?
Yes.
Okay. And how many times has he been there?
Like 5 maybe.
Okay. Anything else you'd like to inform the court of regarding the bond violations?
I'm going to object to the question being overbroad.
Mr. Sandfield, we've been over this once. Why do we need to go over it again? There's evidentiary rules at a bond hearing.
All right, Judge, I'm sorry. Let it go. I'll
I mean,
withdraw.
I'm going to give you every benefit of the doubt, but come on, man. It's around 4 o'clock. We got things to do. I got another court hearing after this.
All right,
Let's get to the meat of the matter and be done with it.
All right, I understand.
Go ahead, Ms. Bruker.
Okay. Did you have anything else you'd like to inform the court of regarding the bond violation, Ms. Mayor?
I do not.
Okay. Judge, that's all I have.
Thank
Judge,
you.
I
Mr.
have a few
Sandfield, cross-examination.
Judge, could I take just a real quick moment to use the bathroom, and I'll be right back because I've been sitting for a while. I need to run to the bathroom. It'll just be a second. Can I take like a 2-minute break, please?
Yep.
Thank you.
All right, we are back on the record in the state of Michigan versus Ryan Schultz. Mr. Sandfield is back with us after taking a short break. Mr. Sandfield, I believe that you wanted to say something and then you're ready for cross-examination.
No, I'm just going to go into the cross-exam if I could.
Right ahead.
Thank you. Ma'am, you stated that on that last police report you made, you said it was because you asked Ryan to leave after he was at your residence for multiple days, and he didn't leave this at the moment you wanted him to leave. Is that correct? Sarah, you have to unmute.
And that's from the one in December.
I'm talking about the one where you called the police and said he was at your house for multiple, you said he was at your, when the prosecutor said to you, why did you call the police on that day? And you said, because Ryan was at my house for multiple days and I asked him to leave. And so that's the reason you made the police report, but you didn't say why. Is that because you say he didn't leave when you wanted him to? Pardon?
I did call them. I don't understand what you're asking me.
Well, I'm saying, why did you call the police?
In December,
Yes.
because he was at my house up north and he
No,
wouldn't leave.
I'm not talking about that one, the picture of his vehicle.
That's the one you're referring to, though.
I'm referring to the time you said that you made a police report when Ryan was at your house for multiple days and you asked him to leave. Is that the one we're talking about?
Yes,
Okay. And we say multiple days. Were you there?
I was there. I didn't have a house down here yet.
Okay. So you were still living at the residence in Gaylord.
That's correct.
Okay. If he was there for multiple days, obviously you agreed to that and it was okay with you during that time frame, correct?
I'm going to object to that. I don't think it matters. You know, I don't think characterizing her as being okay with it is what the court's going to be deciding today. The court's simply going to be deciding whether or not he violated his bond by being around someone who was court ordered not to be around.
Judge, there's mitigating factors and there's more to this than just saying there's a technical violation. So I think that question is very appropriate.
I'll let you ask it.
Ma'am, so you were to Ryan being there with you and living with you for multiple days, correct?
Yeah.
Okay. And during those multiple days, there were days of encounters as well, correct?
No.
Were there days since this case started, were there any days where you and him engaged in activities?
Yes.
Okay. That was by your consent, correct?
Yes.
And that was what, a time period when the no contact order was in place, correct?
It's still in place, correct?
And then when this no contact order was in place and the date he lived at your residence for multiple days, why'd you call the police? You used this, if he was there and by consent, why did you call the police? Because he didn't listen to something you wanted him to do?
I wanted him to leave. He had already been there multiple days, and I didn't tell him he could stay that long. He said he was going to be visiting our daughter, but then it turned into just badgering me whenever she was asleep about, let's just have another chance, give me another chance, blah, blah, blah. And I was over it, done with listening to that every day. And I was like, I want you to leave. I want you to get out of here. Like, you're not even allowed to be here.
Okay, but you had consented for him to be there, right?
At the time, yes, I
Okay.
did.
So you used this no contact order when it was okay for him to be there at certain times, but when you decided you didn't want something to take place, you used the no contact order in that regard, correct?
I'm gonna
If I
object.
didn't
It's
want him to
argumentative.
be
I'll
around
withdraw that
me,
question. I'll rephrase
Stop.
that question.
Stop. I can only have one person talking at a time. When Ms. Mayer is talking, nobody else is talking. When Mr. Sandfield is talking, nobody else is talking. When Ms. Bruker is talking, nobody else is talking. So, Mr. Sandfield, rephrase your question.
Thank you, Judge. So would it be fair to say that you were using the no contact order at that time to pressure Ryan into leaving the house because you decided it was time for him to go?
no, absolutely not. I would not say that that would be a fair thing to say. I didn't have to pressure him not to be there. He wasn't supposed to be there. I
Well,
allowed him to come visit our daughter, and then he was staying longer than we had agreed on.
how many days did you agree on?
A couple, and it was like 10.
He was living to you for 10 days before you called the police?
That's correct.
Okay. So you're not really afraid of Ryan, correct?
At times, it depends on what's going on.
Now, haven't you told him in the past, while this case was pending, that you were really not afraid of him?
I'm gonna
At
object to that. I don't
times.
think that's a relevant question for a bond violation.
I think it is relevant, Judge. It's a mitigating factor on a technical
Mitigating factor,
violation.
whether she's afraid of him or not, what does that make in a bond violation as to whether or not the court ordered him to stay away?
Well, Judge, the bond violation, a no contact order is designed to ensure that a defendant appears in court and that the public is safe at large and that the complaining witness in a domestic violence case is not intimidated or threatened. And I think it's a very fair question when somebody during a domestic violence case is allowed to stay with you for 10 days, then all of a sudden I want you out, so I'm going to utilize the power that I have to get you moving. I think that's a very relevant question. I think that I'm not going to give you my thoughts, but I think the question is something I'm asking the witness that I think, Judge, that she should be required to respond to that.
Purpose of a no contact provision is also under the court rules MCR 6.106 D2M if it's reasonably necessary to maintain the integrity of the judicial proceeding. That's exactly why we don't want defendants and victims together so that one is not or is alleged to have not power or control to manipulate, intimidate, or coerce another witness. So you go where you want to go, but I don't think it's going to do you any good today, Mr. Sandfield. Okay. So let's shoot up.
All right, I'll speed. Now, isn't it true, ma'am? You asked Ryan to put him on the deed to his residence?
I don't see how that's relevant.
Mr. Sandfield, come on.
Oh, Judge, I'm trying to just show you that there's no contact.
I can show you text messages over the course of our 5-year relationship.
Stop. Hey, nobody gets to talk when I say stop. There are rules that need to be followed. One of them is do what the judge says. Mr. Sandfield,
sorry, sir.
I get where you're going with all of this. You want to say that this is consensual behavior and that she asked for it. You've made your point. This whole hearing is without evidentiary rules. I get what you're doing. Okay. Why do you need to subject me to more of the same?
All right, I'm just going to ask her a few more questions. And with regard to my exhibits, I'm just going to ask her ma'am, you're not disputing the fact that you initiated contact with Ryan as well, correct?
At times, yes.
Okay. And then this Gayla, that picture, that number 3 at the house, you had already vacated that residence and moved into your residence in Heartland, correct?
No, it's not vacated. Over half of our belongings are still there.
but you weren't living there, right?
I was still going back and forth between both houses.
Okay. And, but Ryan was never there when you were there,
During what period of time?
when that picture was taken.
I was not there when that picture was taken. Ryan was.
Thank you. And I'm not going to go into all these exhibits because the judge has got a good picture of it. He's got a good handle on this. But you do agree that, did you review defendants exhibits 1, 2, 3, and 4?
Of yours?
Yes.
I've seen some of them. I'm not sure if I saw 4
Okay.
of them.
You're not disputing that there's a multitude of occasions here that you did contact Ryan. Is that correct?
I'd have to see what they are.
Well, I don't want to spend this time going over all these. You just said there was. I'll go over the exhibit 1, starts off with, please water the plants right away heavily. The hibiscus takes about 10 orange cups of water, and each other plant is 1 orange cup. Thank you. I appreciate it. Did you send him that text?
Yes, that was after he was not supposed to go to the house. He went there anyway. I saw on the camera that he was there. So I texted him asking if he could water the plants because I hadn't been there in a little over a week.
Right. You weren't living there at that point. You had the Heartland residence, right?
Yes, that's correct.
Okay. All right. And then you did text him telling him to water the plants on that day.
Yes.
Okay. And then in exhibit 2, the first page, do you remember sending him a text stating $1,800 is all of you paid last month? I don't care where you're coming up with the 6,000. Remember sending him that?
Yes.
I continued on the next line. So you can send something, even if not the full amount I requested on Zelle. Otherwise, stop calling me.
Okay.
Does that mean if he pays you the 6,000, it's okay to call?
6,000.
Does if he pays you the 1,800 you were asking for, does that mean it's okay to call?
So we came up with our own agreement for child support, and he was paying me 3,000 a month. He had only given me 1,800 that month at that point in time. So he kept calling me, being like, please talk to me. And I said, send the rest of the money, or I have no reason to even get on the phone with you. You're not even going to pay your child support.
So because you led Ryan to believe that he paid his child support, he could be on the phone with you, right?
That's correct.
Yes. Okay.
Yes.
All right. So then I don't take up all the judge's time because there's a dispute. There's a technical violation here that there was some contact. But again, you agree too that you were not threatened or afraid of him during these times where there was communication between you and him, correct?
I'm gonna object to that again. We kind of been through this already.
Ask your question. Let's be done, Mr. Sandfield.
Ma'am, during these times you were communicating with Ryan, you were fair to say that you were not afraid of him.
I'm gonna object to
Yes,
that, Judge. I
fine.
don't think, again, I'm trying to belabor this, but I don't think it's a fair question to ask her.
What court rule states that a question is unfair, counsel? I've never
What's
heard
the
of an
relevance,
unfair objection.
Mr. Sandfield, what's the relevance to a bond hearing or whether or not the victim is afraid of the defendant?
Well, because one of the bond here, a bond by strike that. One of the objections of a no contact order is protect the victim, a victim who claims typically a lot of times they're entered to protect the victim because they're afraid of the defendant because there's an allegation of violence. I think it's quite obvious that doesn't exist here, but I would just like the complaining witness to articulate that.
The court rule also cites, and I read it already and I'll read it again, MCR 6.106 D2M says that a bond violation of no contact is appropriate if it's reasonably necessary to maintain the integrity of the judicial proceeding. This case right here is exactly why we have no contact provisions, so that the parties are not sandpapering each other one way or the other or by both.
I understand, Judge, but I don't think there's been any.
I'm sustaining the objection. Move on, counsel.
Okay. So on some of these days, now you said earlier that Ryan didn't know where you lived at the Heartland residence. Obviously, you voluntarily provided that to him so he could stay with you during that 10-day period, correct?
I didn't say he didn't know where I lived. And when he was with me for 10 days, it was up north in Gaylord before I had Heartland.
But he's been to your residence in Heartland also, right?
Yep. We already talked about that.
You provide that address to him in that location, correct?
Yes.
And he stayed overnight there a few times too, didn't he?
Yes.
All right. Judge, I think you have the picture. I'm not going to belabor anything further. I'm done. I have no further questions of this witness.
Thank you. Ms. Bruker, any additional witnesses or evidence?
Can I just ask her one quick question, Judge? It'll be quick.
Go ahead.
Ms. Mayor, Mr. Sandfield had asked you about some of the exhibits. Did Ryan send you any of those exhibits?
Yes,
So some of the text messages Mr. Sandfield's referring to, you had received those from Ryan.
correct.
I don't have any other questions, Your Honor.
I do have one other question real quickly. Last time this case was scheduled, you failed to appear, and that was because it was our based on information belief you didn't want to pursue the bond violation. And is it true that right after that the prosecuting attorney sent
I'm going to object to this. I know what he's going to ask, and it's totally inappropriate.
Mr. Sandfield, you don't get to question what the prosecuting attorney does.
Let me
They have
rephrase.
absolute discretion to do whatever they want to do pretty much in a criminal case. They have the authority and the discretion to do that. You don't get to question them on
Right.
that. They're not a party to the case.
All right, let me ask, I'll try to rephrase it real quickly. That after that, you failed to appear for that bond violation hearing this most recent time. Did 2 uniformed police officers appear at your residence?
I'm going to object to that because it's not relevant to this, and it's beyond the scope of a bond violation. I can, if the court wants information about that, I'm willing to do an offer of proof.
I don't. It makes absolutely no difference what the police did or didn't do.
Gotcha, Judge. Then I'm good.
Do you have any witnesses or evidence that you wish to produce, Mr. Sandfield?
Dr. Schultz, is there anything you would like to say? Or I'm of the opinion that you don't need to testify today. Are you okay with that decision?
Yes.
Are you
Would there
okay?
be anything that would be relevant to clarify with regards to what was questioned and asked, or not relevant?
All right, let me just,
I guess, can I make one comment about one of the things that was just said? I guess I have a few, but one thing would be that I had prepaid the child support.
No,
Hang on,
Sorry.
no, that
Mr.
doesn't, no.
Schultz, you don't get to make
Don't-
comments.
Okay, sorry.
If you're
that's what I
gonna
was
tell
wondering.
me, hang
I'm
on,
not
if you're
gonna-
gonna tell me anything, it's gonna be under oath, subject to cross-examination. So it's either all or nothing. There aren't minor comments. So,
I'm
Mr.
not,
Sandfield, do
I
you
don't
have a
have any-
witness that you wish to produce?
No, Judge.
Closing arguments, Ms. Bruker.
I think, the court clearly understands the issues. We've had a no contact order in place since approximately, I think, August or so when this case was filed. Ms. Mayer testified that Mr. Schultz has repeatedly had contact with her throughout the case. We focused on the time period following the last hearing, just because we did, dismiss the other bond violation, and because right after that hearing, when the court again clarified with him he was not to have contact with her, he immediately starts sending her those text messages and calling her and leaving her voicemails and doing all of this other stuff. I've had probably 20 conversations with Mr. Sandfield. I'm not exaggerating. In every conversation, we talk about the no contact order and how his client should not be having contact with her, and yet we're here. So I'd be asking the court to revoke his bond. I believe this matter is on the trial track and is going to be set for trial.
Judge, 6.106 states for us that there's reasonable conditions to be put on bond. And also revoking the bond is the most aggressive thing the court could do. And the purpose of bond is, to a large degree, is to be sure there is an appearance for court hearing, and that the public is safe, and that the complaining witness is safe. I understand there's other provisions within that rule also for the integrity of the court and so forth. Although I don't believe there was anything that was brought forth today that would lead the court to believe that those other provisions really are applicable. This is not a case, Judge. We're not talking about stalking. There was no intimidation. There was no harassment. This is just a serious couple and engaging in mutual ongoing communication regarding their relationship and their 4-year-old child. It's quite obvious that this woman is not afraid of Ryan because she allowed it. They lived together for 10 days. There were other occasions too. And she lived together for 10 days. And she's using this no contact order, not to protect herself, but as a control and power mechanism. It's okay for Ryan to stay in her house for 10 days and not have any problem with the no contact order. But the second she decides she wants something, she uses it for power and control. And that's where I wanted to go with it when you cut me off. I wanted to go show that she's done other things to use this, not because she needs it for her safety, but rather to manipulate Ryan into making payments and doing things. Otherwise, she will use the no contact to her advantage. That's not its purpose. Sure, we have a technical violation here. I'm not going to sit here and tell you that there hasn't been contact, but it's been mutual. It's been cordial. There's been no threats. There's been no harassment, been no intimidation. There's been mutual contact, and many times was initiated by the complaining witness, who's admitted that today. So yes, there is a technical violation to revoke the bond and say, Ryan, you have to sit in jail. We're not giving any bond because you stayed with your girlfriend for 10 days. And when she told you it was time to leave, you didn't leave fast enough, so she's going to implement the bond condition of no contact. I don't think that's the purpose of it. So yes, we're going to state there's probably a technical violation, but there's a lot of things you can do to modify this bond condition other than revoke it in its entirety and place my client in jail. He's employed, he's 40, he's essentially devoid of any criminal history. He's willing to even post an additional cash bond if the court feels that's appropriate. He's willing to meet terms and conditions just as long as it continues to allow him to maintain his employment. And I also think that, I know it's 4:30 and you want to leave, and I also think that the testimony you heard today falls within the parameters of my motion to remove the no contact order. So I'd ask you also to remove that, because you can see there's no need for the no contact order when the complaining witness allows the defendant to sleep with her for 10 days.
Thank you, Mr. Sandfield. I know that the defense exhibits were not admitted, but I've read through the defense exhibits 1 through 4. I can find at least, I've got sticky notes on them. You can probably see them here on the edges. There's got to be a dozen different places where I wrote in the margins, emotional pressure, talking about how to resolve the criminal case. These are all messages that the defendant sent to the victim. Emotional and financial pressure, talking about the criminal case status, negotiating the criminal charges, or trying to specifically discussing the change of charges and the case disposition, and further discussing the case and changes and charges and trial. And these are in the defense exhibits. There are literally dozens, if not hundreds, of contacts that the defendant made to the victim. I get that the victim acquiesced in some of them. I'll even go so far as to say that she initiated some of them. But I have yet to see the volume that this case tells me of the defendant going out of his way to talk to have contact with, to pressure, to put emotional pressure on the victim in this case. This is classic power and control in a domestic violence case. There isn't any way to spin it otherwise. And I appreciate Mr. Sandfield's arguments. I appreciate the time and effort that he's put into those things. I get where he's going with that. I've been a prosecutor for 20 years. I've been a defense attorney for 15 years. I thought I had seen just about everything, but I have not seen this level. I don't even know what to call it other than chutzpah in saying no contact from August forward, no contact again in the hearing in January. And here we are arguing about whether or not it's okay for him because she said so. There isn't any okay from her. This is the judge telling you not to have contact, not because she needs to be protected. That may be one of the reasons, but because it's inappropriate to have contact between the parties in a criminal case so that there is no coercion, force, all of the things that go into this case that make it such a struggle to get to where we are today. You don't get to create a mess out of the court system. And that's exactly what the defendant has done today. He has initiated, he has pressured. The phone call that was played in, or the text message that was played in court today was him using emotional issues, please, 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 whining, using emotional context to try to get her to do something for him. The defense exhibits that I reference are him emotionally trying to put pressure on her and talking explicitly about the criminal case. That's interfering with the criminal justice system. Quite frankly, you could be charged with a crime for witness intimidation. I don't know that you understand the depth of the stupidity that this whole bond issue generated. I can't, I can imagine a worse scenario. Could be a lot of violence. But for a lack of violence, this case is the worst bond violation I have ever seen. Mr. Schultz, where do you work?
Raylan Family Dentistry, Your Honor.
Where do you live?
I have been jumping around currently.
No,
But
not
my
going to do that. Where do you
residence
live?
is
Where are you going to live?
Wilkinson, Gaylord, Michigan, Your Honor.
Is that the home that you share with the victim in this case?
Yes, Your Honor.
Ms. Brucker, is there any reason that she needs to be there at all for any purpose?
No, I don't believe so at this point.
I do have a residence in Royal Oak as well, Your Honor, if that's helpful for the interim currently.
I do
You're
need
gonna be
to
able to-
still go.
No, I'm not listening to anything else. Where are you going to be able to work if you live in Royal Oak?
I've been driving back and forth and staying at the hotel, been staying in the vehicle depending, or at the house when I was allowed to.
No, I'm
yes, Your Honor.
I'm not putting you anywhere near her anymore. You may
Yes, Your
go from your home. Here's bond conditions. You may go from your home to work and back, period. How long does it take you to get from your house to work?
About 30 minutes, Your Honor.
You've got 30 minutes from the time that you leave your house to get to work and 30 minutes to get back. What time do you work?
I work like 9:30 a.m. It kind of varies. It could be anywhere from 7 p.m. till like 9 p.m. If you have a cutoff time, I'll make it happen, Your Honor.
9:30 to 6:30. You may be at your work.
Judge, can I respond to that?
You may leave your home at 9 o'clock. You must be back in your home at 7 o'clock. If you are outside of your home, outside of those hours, you are going to jail.
Your Honor.
If you need food, or if you get it away home or get it on the way to work, if you need something more than you can get in a quick dash like that, DoorDash it.
Yes, Your Honor.
You are not to leave your house, period. Weekends included. You got 9 in the morning, you can leave. 7 o'clock, you got to be back. You will be in your home at all other times.
Yes, Your Honor.
You may not have any contact. I don't care what the context is. No contact means no contact. If it's you personally, if it's by computer, by social media, if it's by third parties, I don't care who it is. If somebody contacts them and says it's on your behalf, you're going to jail. You understand that?
Yes, Your Honor.
In case you haven't noticed, I'm not happy with you. You do not want to tick me off anymore.
Understandable, Your Honor. I'm sorry.
Do we need to put this on for jury trial as quickly as possible, counsel?
Judge, with regard to the 7 p.m., my client, a lot of times, he tries to make it at 6 or 7, but if he typically runs an hour or 2 hours behind if he has emergencies. So I know for a fact he sometimes runs till 9 o'clock. He's a dentist, and if he has emergencies or gets behind, it's impossible to predict an exact time. You can't stop a procedure and say, oh, by the way, I'll take the rest of your tooth out tomorrow. Would it be possible to extend that time frame a little bit to allow him to at least address some problems that occur after 7?
Counsel, that is a great suggestion. The only problem with that is he's burned so many bridges. I have no ability to believe that he will do that. In case you haven't figured it out yet, I don't believe a single thing that he says.
Could we push it maybe to 8 p.m.? Please?
No, the obvious answer to that is I could put him in jail today. Would you like me to do that?
Obviously, that we're not asking for that.
I would hope not. So I'm being generous today now. This is
Judge,
me being generous.
Judge, I agree. You've been real fair with us. You've been real patient, and I'm not disputing anything. And even though I'm an out-of-town attorney, I think you're treating me with dignity and respect and giving us every break that you can. And I'm not disputing anything you just said. I realize for me, I've never been in this court before. So, I mean, sometimes.
It's got nothing to do with you. It has absolutely nothing to do with whether you're from this court or not. I just find these facts to be outrageous. And so I'm trying very hard not to put your client in jail.
Thank you.
So do we need to have a quick jury trial date?
No, we don't need to expedite this, do we, Dr. Schultz?
Whatever is convenient.
Could we do, Judge, like maybe a final pretrial? And I was going to ask you to set it out to May.
Why do we need to go that far out?
I'm hoping that a resolution can be achieved, and maybe I'm kidding myself.
I would hope that a resolution could be done as well, but we wait till May and then there's no resolution. I've lost 2 months doing nothing. This case has been pending since August of last year. We're already in March, so we're 7 months down the road. I'm supposed to have these cases resolved within 6. So you're already on my time clock. So I'm pleased to give you an opportunity to discuss resolution with the prosecutor, talk it over with your client. I'm happy to do that. But I need to have a resolution relatively quickly. I'm gone the next 2 weeks. We got time on the 9th or the 16th?
Yes, we have room on the 9th in the afternoon.
April 9th for another status review, 1:30 via Zoom. We're either going to have a plea or we're going to set it for trial.
Okay, thank you, Judge. That will be April 9th at 1:30 by Zoom.
Yes.
Perfect. Thank you, sir. Have a great 2 weeks off.
Mr.
Your
Schultz?
Honor. Yes, sir. Your Honor, if I'm not in Gaylord at the moment, do I need to report back there? I'm assuming immediately then, or am I able to go back at the end of the next couple days?
You got 2.5 hours to get home.
Okay. Alrighty. I'll make it happen, Your Honor.
Anything else, Ms. Bruker?
No, Your Honor. I don't think the court was considering this, but community corrections may have a tether available if the court's concerned about that as well.
You tell me if there's any further conduct or contact, there's going to be a jail order. So I don't need a tether. If he's dumb enough to do something like that, that's him.
Okay.
Thank you. That's all for today. We're in recess.
Oh, Judge, with regard to my no contact or my motion, I'm assuming that that's no traction, or could we take another look at that on April 9th?
I didn't understand your question.
I filed my motion to remove the no contact order, and because of the time, we didn't really get to it. Could that be pushed over to April 9th, please?
No. The answer to your question,
Okay, I understand.
we're in recess. Good afternoon, everyone. Welcome to the 87A District Court. I'm Judge Hesselink. We'll get started with the civil docket this afternoon. First case is Check and Cash USA versus Riley Perry. It's file 24-39514-SC. Who do we have present for that matter, please?
Rachel here, Your Honor, from Check and Cash.
Thank you. We have Riley Perry with us. Rachel, have you had any contact from Ms. Perry?
I have not.
Looks like she failed to appear back in June, according to my notes. Is that right?
Yes. And then I just got a notice to appear and it says for a bench warrant arraignment for today.
We were going to try to do that and the civil discovery subpoena at the same time. Apparently she got served with the bench warrant. At least that's what I'm guessing. We had any contact from her? You don't see her in the waiting room?
I do not.
Well, guess we're going to have to do another bench warrant for her and raise the bond amount.
Excuse me.
All right, for her failure to appear, we will forfeit the bond that she's posted and set a new bond at $500 cash or surety. Rachel, if you do have some contact with Ms. Perry, make sure that she contacts the court. Otherwise, as soon as we get some new information from her, we'll let you know.
Okay.
Matter is Credit Acceptance Corp. versus Malcolm Wilson, file 26-42198-GC. Who do we have present for that matter, please?
Michelle Bourne Fisher, P67527 on behalf of plaintiff.
Thank you. We have Malcolm Wilson with us. Counsel, have you had any contact from Mr. Wilson?
I have not.
I do see an answer that has been filed. Basically, it says engine blew in the vehicle and you can have the vehicle back if you want it. I'm assuming you don't want it.
We do not. I believe, do you have our motion for summary disposition as well as the pretrial?
I do.
Okay,
I don't see, I think this is the first contact I've had with the case, though. Typically, I give pro se defendants, I'm sorry, what's that?
You hear me? This is Malcolm Wilson.
Oh, Mr. Wilson, you are here. I can hear you now. Thank you, sir. This is a pretrial, and there's a motion by the plaintiffs for summary disposition. Have you received a copy of their motion for summary disposition?
I have.
Have you submitted? I have not received a response to that. Have you tried to submit one?
I didn't know I had to respond to anything.
You don't have to, but you're entitled to if you wish to. But we can proceed today then. Would it be of assistance to you, Mr. Wilson, to speak with the attorney first to try to resolve this matter, or how do you want to proceed today?
Yeah, I mean, I wrote you guys a letter over the whole ordeal. And
Yep,
yeah,
I did see that.
the lady was laughing about it. She thinks it's a joke. So I can't afford 20 grand over an engine that blew on the truck. That's supposed to be a decent truck, but the engine blew within like 3 months. So that's
do you
where
want to talk? Do you want to talk to her about it, or you want to just have a court hearing?
I could talk to her.
yeah, that'd be great.
All right. I'll put both of you in a private breakout room. If you reach an agreement, you will come back and we'll put that on the record. If you don't reach an agreement, we'll decide how to resolve this case going forward. All right. We'll put you both in a breakout room and we'll come back to you as soon as you're done.
Hello.
Next matter is Synchrony Bank and Ryan Jones, file 26-42042-GC. Who do we have present for that matter, please?
I'm here, Your Honor.
All right. I do see Mr. Jones is present. Do I have anybody representing Synchrony Bank? Mr. Jones, has there been a settlement in this case?
I think so. I believe they're filing dismissal. I'm still waiting to hear back on that, though.
When was the last time you had contact with them?
Last Monday,
And what was the extent of that?
we were trying to figure out why we couldn't get a hold of. We were trying to get on this call, and we are having trouble. And so we both were talking, trying to figure out how to get on the call.
All right.
And she said if I got on the call to let you know that she was planning on filing dismissal.
All right. Because I did note that both of you failed to appear at the last hearing, so I assumed that something went wrong or somebody got the wrong information. So that's why we scheduled today's hearing to try to get that resolved. So I'll simply indicate that you appeared and that the case is likely to be dismissed, and I'll wait for that paperwork to be sent in by the plaintiffs. Thank you, sir. That's all for today.
Thank you.
First National Bank of Omaha versus Denise Gilling, file 26-41889-GC.
Good
Who do we
afternoon.
have present for that matter?
Good afternoon, Your Honor. For the record, Albert Kim, P70301, appearing on behalf of plaintiff.
Thank you. I do see Ms. Gilling is with us.
Your Honor, I've been speaking with Ms. Gilling periodically for this while, but could I have a breakout room with her briefly?
Absolutely.
And
Ms.
can you
Gilling, is that okay with you?
Yes, yes.
All right,
And
we'll
Judge,
put you in a
can you
breakout room. Once you guys have resolved your differences or at least talked, we'll have you back in and we'll take your case again.
And Judge, one more thing. Can you confirm what is on today's docket? Because I have a creditor's exam, and I think there might be a motion set aside, but I'm not clear.
Yes, there is a motion to set aside a default, and then there is a subpoena that looks to have the wrong information on it that my staff is asking me to take a look at as well.
Well, that's good to know. I'll speak with Ms. Gilling.
All right, thank you. Next matter is Tina Mix and Alicia Courtier. It's file 26-42144-GC, set for a motion today. Who do we have present for that matter, please?
Alicia Courtier, Your Honor. Tina Mix,
you.
Your Honor.
All right, this is a motion by Ms. Courtier to compel discovery. What I'm going to do is I'm going to put both of you in a breakout room together so that you can discuss in detail what Ms. Courtier thinks is missing and what Ms. Mix has provided and may be able to provide. And hopefully you guys can reach an agreement as to what, if anything, still needs to be done. I believe you're scheduled to go to mediation on this matter coming up later this week. Is that correct?
Correct.
All right, so I'm going to put you in a breakout room. If you guys aren't able to reach some sort of an agreement, I'll have you back in and we'll try to resolve it at that point. But I think both of you discussing these things in detail between each other is the fastest way to resolve those issues. So we'll put you in a breakout room. You can come back in when you're done. NCB Management Services and Amber Wright, file 25-40133-GC. Who do we have present for that matter, please?
I am, Your Honor, Amber Wright.
All right, I do see Ms. Wright is present. Who do we have representing NCB Management Services. All right, Ms. Wright, it looks like the plaintiff failed to appear previously. So for their failure to appear today, I'm going to dismiss this matter. So the garnishment is dismissed.
Okay,
Any questions, ma'am?
So it dismisses the garnishment. Does it dismiss the prior judgment or?
No,
I
it does
should probably
not.
work
Prior
with that.
judgment remains in effect. It's simply, the
Okay.
only thing that's pending before the court is the garnishment and the objection. So that's what's going to be dismissed. All right.
Okay,
Any other
that's what I
questions?
figured. I
that
was
you-
not familiar.
No, that's
Nope,
a
no
good
other-
question. All right, that's all for today then. Thank you very much.
Awesome. Thank you so much.
Jefferson Capital Systems versus Timothy Jones, file 26-41894-GC. Who do we have present for that matter, please?
Good afternoon, Your Honor. Sarah Belzer appearing on behalf of the on behalf of the plaintiff, excuse me, sorry.
Thank you. We have Mr. Jones with us. All right. Looks
And
like
I believe he
Have you-
failed to appear at the last hearing as well. So we had sent in
That is-
a default judgment as the court had requested. Be prepared.
you've not had any contact from Mr. Jones?
I have not.
I'm showing.
Yeah, counsel, does not look like we've received yet the proposed default judgment.
Okay.
What is it that you're asking for in that?
We're asking for costs, filing fees of $75, service fees of $50.35, attorney fees of $75. So the total with that is $2,663.91 because the underlying amount is $2,463.56.
All right, all of those amounts appear to be appropriate to me. The base amount of 2463.56 was what was stated in your complaint. The other amounts appear to be the standard attorney fees and service and filing fee amounts. So I would be happy to sign a judgment for that amount under a default judgment. So if you can track down where that form is, I'd be happy to sign that in the next few days if you can get that to me. Anything else that we need to do today, counsel?
Should we e-file that, or is there an email address you'd prefer it be sent to?
Yeah, I wish you could e-file it, but we don't have that. So there is an email address, and I'll let my staff member let you know what that is, so I make sure we get it right.
Okay. Thank you.
It is a good GOOD
Let's see.
county
County.
MI is in Michigan.
mi.gov.
That's correct.
Okay. Thank you so much, Your Honor. And to
All
your
right, have
staff.
a good day.
You too.
Velocity Investments versus Dustin Everett, file 26-42388-GC. Who do we have present for that matter?
Good afternoon, Your Honor. Andrew Cates, P78292 for Velocity Investments.
Thank you. We have Dustin Everett with us. All right, I do see Mr. Everett is present with us.
Yes, I'm here.
Parties, thank you, Mr. Everett. Have the parties tried to discuss the matter and resolve the case?
I believe this one is resolved, Your Honor. The defendant has sent back, a consent judgment to our office. We were requesting $3,027.45. Court costs and service fees of $137.67 for a total of $3,165.12. The defendant has agreed to pay an initial payment of $337 on the 31st of July, and then following that with recurring monthly payments of $337 beginning August 28th, 2026, and the rest of the payments will be due on or before the 28th of each month. While the payments are made, the plaintiff will not pursue a periodic judgment.
So basically a conditional dismissal?
This was signed as a consent judgment, Your Honor.
All right, that's fine. No problem with that. But no enforcement action as long as he's making his payments, right?
Correct.
All right, that sounds good. Is that what you've agreed to, Mr. Everett?
Yes, sir.
And nobody has promised you anything other than that? Nobody threatened you in any way, and you're doing this of your own free choice and free will?
Yes, Your Honor.
All right. Have you already signed that document, Mr. Everett?
Yes, I have, Your Honor.
All right, counsel, as soon as you can get that to my desk, I'd be happy to sign that as well. Is there anything else that we need to do today?
No, Your Honor. Thank you so much.
All right, that's all. Thank you.
Thank you, Your Honor.
So Mr. Wilson. All right, the court will recall the matter of credit acceptance versus Malcolm Wilson, file 26-42198-GC. I do see Mr. Wilson is back with us. Counsel, were you able to reach any agreement?
Yes, we were. If I could put those terms on the record.
Please.
Okay, we're going to enter into a conditional dismissal for the reduced amount of $4,167.76. And that is going to be paid by November 1st of 2026. I do have permission to sign the conditional dismissal on behalf of Mr. Wilson. And I did take down the email address if we could file it that way instead of, since you don't have e-file.
Yes, you certainly may use the email address. Mr. Wilson, you've heard what counsel has said. Is that an accurate statement of your agreement?
From what I understand, they're taking away 80% of what I owe, and I only have to pay 4,000 and some change. Is that correct?
$4,167.76 is what she said. Is that what you agreed to?
Yeah.
And you agree to pay that by November the 1st?
Yes, sir. Yep.
All right. Has anybody promised you anything else to get you to enter into this agreement?
No, sir. No.
Has anybody threatened you in any way to get you to agree to this?
No.
So you're doing this of your own free choice and free will?
I am. Yep.
And you understand that this will become a court order and would be enforceable as a court order?
I understand. Yeah. Yep. Yes, sir. Yep.
All right. Then once that document reaches my desk, I would be happy to sign that, and then you will make the payments as you've agreed to. And that would be the end of the matter once you're fully made those payments. Any other questions that you have, sir?
I don't. No, sir. No.
Counsel,
No,
any
no.
other questions or statements?
No.
All right. That's all for today. I'll wait getting that documentation from you. Thank you both very
Okay.
much.
Thank you.
Thank you.
Ms. Courtier, I see you, but I do not see Ms. Mix back. What happened?
I explained to her that she still has not provided any itemized receipts. She stated that she does not have any itemized receipts. I explained to her that some of the charges that she claims on her credit card are inaccurate for what she claims they were for. She asked me if, she said she doesn't have receipts. She threw them away. There's no way to tell what was her spending and my spending just by a credit card statement. She started yelling, swearing, hung up.
Your Honor, that's not true.
Well, then why didn't you guys take more time to talk about this?
Well, because Your Honor, all she kept doing was talking over it, screaming and hollering at me. And she's trying to get me to produce something. I don't have cash receipts. Even today, I throw them all away. Why would I keep them in Mexico? It's not like I could return them. I don't have cash receipts. I have the credit card receipts. I have all the documentation, the pictures, the broken down into a spreadsheet with itemized.
Okay. Slow down. What did she ask you for?
The piece of the receipts from the cash register.
All right. And you told her that you did. Did you tell her that you don't have that?
Yes, sir, I did.
All right. What else did she ask for?
She says some of my items were not correct. She says the hotel did not charge.
Slow. Hey.
I'm sorry.
When I say slow down, I apologize if you don't understand that means stop. Okay. So I'll try to be more clear when I speak in the future. So if something is not accurate, that's not an evidentiary, like a motion to compel issue. That's a trial issue. Okay. So that's not today. If you disagree with the accuracy of the documentation, that's for a different day. So what else did she ask for, Mrs. Mix?
I don't know, Your Honor. It got to the point where I left the room.
That's the problem. Ms. Mix, I'm trying to keep this as calm as possible. All right. So leaving the room is not acceptable. The two of you need to learn how to talk to each other in a business-like fashion, because that's what this is. Today is only about business. She wants some paperwork, and you either have it or you don't. If you have it, she's entitled to it. If you don't have it, she's not entitled to it. So, Ms. Courtier, was there any other documentation that you requested that you want still?
Yes, Your Honor, I asked for a witness list in my interrogatories, and she only stated in her interrogatories that she reserves the right to call any witnesses at a later date.
All right, so I want you both to, we're gonna make a list. So both of you write this down. Witness list.
What
Ms.
are the
Courtier, is there
witnesses?
anything?
I'm sorry.
You're gonna go, Ms.
Or
Mix, you're
testify.
gonna go talk to her in a minute in a breakout room about that. Is there anything else that you've asked for, Ms. Courtier?
Your Honor, the reason why I'm asking for itemized receipts is because the plaintiff did a lot of shopping in Mexico.
I don't know why. I don't want to know why you're
Okay.
asking for them. All I want to know is what you are asking for. And then if
Itemized
she,
receipts showing what was purchased at each place, not just the credit card statement.
all right, so we're going to talk about that. What's the next thing that you want to ask for?
Your Honor, I do not have those receipts.
Ms. Mix, we're going to get to that. If you don't have them, that's what you're going to say, and that'll be the end of it. Okay?
And the
But-
payments,
Go ahead.
the
Next
payments
one.
that I have made. I've already paid this off, and I showed her a calendar event. Your Honor,
I'm
she
not,
even-
hey,
she
stop,
stated-
stop. I don't want to know why.
Okay, sorry.
I only want to know what documents are you asking for? What is the next amount of documents that you want?
My payments.
Records of defendants' payments. What is the next area of inquiry? What else do you want her to produce?
That is all, Your Honor.
All right, so Ms. Mix, can you provide her with a witness list? Not who, but
What are they supposed to be witnessing, Your Honor?
things that are important to this case, facts that would be important for you to prove in this case if we were to go to trial. So you need to come up. How fast can you do that?
I don't understand what facts you want. Nobody went on the trip with us.
Then there might not be any other witnesses other than you and her. I don't know that. I don't know what she has said after she came back. I don't know what documents you have sent to somebody else after you came back. I don't know if you have a bar tab from Mexico and you call up Juan, the barman from Mexico. I don't know those things. This is not my case. This is your case. You have to prove that she owes you some money. Who are the witnesses that you're going to use to do that? That's what she wants to know, and that's what she's entitled to get. So you have until mediation. That's the 5th, right? 2 days from now?
Yes, sir.
I'm not sure, Your Honor, because Melissa says that she had to wait until after this court date to set us up with mediation. Ms.
It's
Courtier,
the 5th at 3 o'clock, Your Honor.
I'm sorry, what was that, Ms. Courtier?
It is the 5th at 3 o'clock, mediation is.
So 8/5 at 3 p.m. You must have a witness list, Ms. Mix, and that witness list must be given to Ms. Courtier and a copy sent to the court. And if you try to use somebody that's not on the witness list, I probably will say that you're not entitled to. Because Ms. Courtier is entitled to know ahead of time who you're going to use if we have to go to trial. You understand that?
Yes, sir.
All right. The next item is itemized receipts.
I don't have any, Your Honor.
All right. And the final one would be records of payments that Ms. Courtier made. Do you have any of those?
I have one record of payment she made for $800, but it was split up between 250 went towards the utilities at my house because she was staying at my house. 250 went towards the debt, and the other 300 went towards the money she owed me from a casino.
Your Honor, that payment was not related to Mexico at all.
Stop. Again, I'm not here today about why. All I want to know is what. So sounds like Ms. Mix has a receipt. Have you already turned that over to Ms. Courtier, Ms. Mix?
Yes, Your Honor, I have.
All right. Ms. Courtier, do you have that document?
I do.
All right. So sounds like there aren't any other physical records.
Yes.
If Ms. Mix tries to use additional physical records, the court may, in its discretion, refuse to accept it if she doesn't turn it over to Ms. Courtier ahead of time. Do you understand that, Ms. Mix?
Yes, sir.
All right. Ms. Courtier, is that all of the requests that you have to date?
Can I ask for one more thing, Your Honor?
And what is that?
In her interrogatory, she states there's no written agreement for this alleged loan.
So what are you asking for?
I would just like that to be stated. That's all.
Well,
And I would
today
like,
is only about discovery, meaning what information can you get? Points that you're trying to make there are things that would happen at a trial. You would say, there's no written agreement.
okay.
And I would say, okay, Michigan allows verbal agreements. And then she would have to determine or show me what that verbal agreement was, and you would be able to dispute it if you wish to. But those are all trial things, not pre-trial discovery kinds of things. So it appears that you have everything that you're going to get other than the witness list, and you're going to get that on Wednesday at the mediation. Ms. Mix, do you have that date and time written down and where it's at?
Yes, Your Honor.
All right, so I expect both of you to be there, and I expect both of you to be able to talk to each other, trying to settle this matter in a business-like fashion.
Your Honor,
we
can
were
I
able to,
request?
hang on, let me finish my thought, and then I'll give you a chance. All right. If I am here holding your hands, you guys can talk to each other. I expect you to be the same way with the mediator. That is, attempt to resolve this matter, because quite frankly, you do not want me resolving this case, because I may and probably will not do it in a way that you like. And I'm talking to both of you. So you're always best to resolve these matters yourselves. If you guys can get along well enough to go on vacation with each other, then you can get along well enough to figure out how you're going to pay for it afterwards. Both of you understand what I'm telling you?
Yes, Your Honor.
All right. Ms. Mix, is there something that you had to say?
Yes, sir. I've requested from the beginning. I didn't do it on paper, but I did it at the courts. For Miss Courtier, she claims she's paid me all these payments. I've requested receipts showing that she paid me these payments, and I have yet to receive any of that.
Well, part of that reason is because you didn't ask for it in writing, and that's what you're supposed to do. Ms. Courtier, is there any problem with you bringing with you to the mediation all copies of any payments that you think that you have made?
I have already provided Miss Mix with my payment calendar. She received all cash per her request because she is on a fixed income. There are no receipts and she knows that.
All right, so you're telling me right now on the record that you don't have any additional documentation of payments. You just made notations on a calendar.
Yes, every time I gave her money and she was aware of that. She told me to keep it in my phone on my notes.
Hey, slow down. Again, I'm not asking why. I'm just
I
asking
know, I'm
what.
sorry.
All right, so sometimes it's hard. I get it, but that's how we got to do it. So Ms. Mix, you now know that she doesn't, or same way that you're saying you don't have receipts, she's telling you that she does not have receipts. Is there anything else that you would ask for, Ms. Mix?
Well, I mean, if she doesn't have receipts of payment, the only thing she can show is something she wrote in her calendar. Just because.
Ms. Mix, the question was what, not why, what? What additional evidence are you looking for?
Just a receipt, Your Honor, just something.
All right, she told you she doesn't have it, just like you told her that you don't have receipts. So you guys are going to mediation on August the 5th at 3 p.m. I expect you to talk with each other in a business-like manner. Neither one of you may storm out or leave until you've exhausted your ability to try to resolve the matter. Okay, if you can resolve it, the mediator will help you talk through and put together an agreement, and that will come to the court, and we'll make that part of the court's order. If you cannot reach an agreement, we will set some additional dates as to when we're going to have a court hearing on this. Do either of you have any additional questions?
Your Honor, I had an original docket that the trial was set for August 24th.
All right, that may well be true. That doesn't change. So if we've already got a court date in place, we'll keep it.
Okay.
If you do reach an agreement, then obviously we would use that for somebody else. Okay. All right. Good luck to both of you. That's all for today. Recall the matter of Denise Gilling and First National Bank of Omaha, file 26-41889-GC.
Again, good
Were the parties
afternoon.
able to reach an agreement?
Yes, I'm pleased to report. Yes, and good afternoon, Judge Albert Kim, P70301, appearing on behalf of plaintiff.
Thank you. I do see Ms. Gilling is back as well. Counsel, you want to put your agreement on the record?
Well, Your Honor, we've agreed in principle to defendant paying the settlement amount of $5,000 over 48 months. We're still working on the paperwork. That being said, for purposes of today's hearing and also the future subpoena, plaintiff is requesting that the subpoena be withdrawn at this time. And I believe defendant is also in agreement to remove her motion to set aside to see if we can get this matter resolved without the court's involvement.
Yes.
All right, Ms. Gilling, you've basically indicated that that is your agreement. Is that correct?
Yes, sir.
All right, and you're reaching this agreement without anybody threatening you in any way or promising you anything in addition?
Yes, Your Honor.
So this is of your own free choice and free will?
Yes.
And you recognize that once the details are worked out and it's put down in paper and you've signed it, that will become a court order and can be enforced as a court order?
Yes, sir.
All right. I'm satisfied that the agreement is appropriate. I will look forward to receiving the paperwork once it's signed by both sides. Counsel, are you going to be submitting that shortly?
Your Honor, yeah, I think we're going to try to do this informally or a non-installment payment order, but we will have like a settlement agreement, a post-judgment settlement agreement. So I don't intend to actually put forth a actual order before the court, but I do have the terms worked out and the defendant has agreed to them.
All right, and then part of that order will be that there'll be no enforcement as long as she's paying as requested?
Correct, Your Honor. There'll be no other attempts to try to collect, including anything that would be permitted by law. We will still not do that. Any collection matters. And I'll put that on the record.
All right, so you understand that, Ms. Gilling?
Yes, I do, Your Honor.
So I won't see any further court documents. Parties will, is there going to be a dismissal, conditional dismissal of some kind then, Mr. Kim?
At this time, though, because the plan goes out 48 months, I don't think I could agree to a conditional dismissal on my client's situation, but I think we'll let the judgment stand as is, but we will have this other agreement that will be binding by both parties, and I believe both parties are in agreement with the terms, so.
All right, so the court can just simply let this file sit with the judgment in it, and that's sufficient for both of you?
On my side, yes. Ms. Grayling, do you agree?
Yes, I do.
All right, that's all for today then. Thank you both very much for your assistance. Glad that you were able to work things out. All right, thank you very much.
Thank you, Judge. You have a good day.
All right, so we got our civil matters done.
We got about 5 minutes before.
Yep. The court's landlord-tenant docket begins at 2:15, so court will be in recess until that
Your
time.
Honor, do you have TD Bank versus Jessica Woodruff?
Yeah, yes, Your Honor.
I think my counsel is here, and they never really checked us in, did they, Gary?
They did not.
I originally had it on my docket, but I do not have the file with me at the moment. Let me see why. My staff will check that on the computer. Yeah. 26-422-38 GC.
2238.
Yes.
We do have it on here. It's not in.
Gentlemen, my staff will assist me by grabbing that file. Apologize for missing it. And so we'll be ready to proceed on that in just a few minutes if you'll be patient.
Yep, thank you, Judge.
Thank you, Your Honor.
42238.
Yes, Woodruff. All right, court will call TD Bank USA versus Jessica Woodruff. That's file 26-42238-GC. Who do we have present for that matter, please?
Good morning, Your Honor. I'm sorry, good afternoon. William Saloom, P41487, appearing on behalf of plaintiff.
Thank you.
Yep. And good afternoon, Your Honor. Gary Apps, P046306, subbing for Attorney Honig on behalf of the defendant.
All right, have the parties attempted to resolve this matter?
Your Honor, I think they have been in contact with our office. We don't have it resolved as of today, but Gary, do you need any discovery or do you just need a little more time?
Is this the first pretrial? I don't always know when I get these assignments.
I think
Yes,
it is pretrial.
Well, could you allow like a 60 discovery, 90 for dispositive motions, and 120 if there was a hearing?
Yeah, I have no objection to that.
All right, that sounds good. Any amendments to any pleadings or anything like that necessary?
No, not from plaintiff's standpoint, Your Honor.
No, I don't believe so, Your Honor.
All right, let me get so 60 days. Discovery, do motions for summary disposition at 90 days. And we'll have a settlement conference after the MSD at 120 days. Anything else that needs to be in the pretrial order, gentlemen?
No, Your Honor, I don't think so. I think that should cover
All
it.
right. Thank you for bringing this to my attention and working things out. We'll send this out to you. That's all for today. Thank you very much.
Thank you, Your Honor. Have a good day.
If I ever aspired to be a judge, your last hour made me satisfied I'm not.
I can
I
concur
think
with
that's a
that.
compliment, or at least I'll take it
All it
as
was.
such. Thank you.
Your combination and grade school teacher, so you got to keep parties in line.
Judge, you have much more patience than I have.
Yeah, exactly.
Thank you very much, counsel. I
Have
appreciate
a
the
good
time.
day.
Thank you. Have a great
Thank
day.
you, gentlemen.
All right. Looks like we are back on time for the landlord-tenant matters. All those here that are present for the landlord-tenant matters, there's some information that the court is required to have you listen to. So if you do so carefully, and once that is completed, we will begin our landlord-tenant docket. Thank you very much.
Advice of rights and information, or landlord-tenant. Advice of rights and information. This information explains your rights as a tenant, the defendant, when your landlord has filed a case to evict you. They may also be asking the court to order you to pay money. Notice of rights. You have the right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be for your area. Legal Services of Northern Michigan, 111 West Mitchell Street, Suite 1C, Gaylord, Michigan, 49735. Phone number is 989-705-1067. Fax number is 989-705-7178. And the toll-free number is 888-645-9993. And their website is www.lsnm.org. Place where cases will be heard. You have the right to have your case heard in the county or district where the property or any part of it is located. Look at item 3 on the attached summons, Form DC 104. If the landlord, plaintiff, has checked the box saying that the case is not being brought where the premises is located, you can ask the court to transfer the case to the county or district where the property or any part of it is. You can ask the court to move the case by filing a request, a motion, in writing before the court date listed on the summons, or ask the court in person at the first court hearing. Jury trial. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use Form MC22, jury demand, and file it with the court. You must pay a $50 filing fee when you make your demand or within 5 days of the court explaining your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. Rental and other housing assistance. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, a federal help for homeless veterans program. You should have received information on your local rental and housing assistance with the summons. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint from your case are enough. Michigan Department of Health and Human Services, located at 931 South Otsego Avenue, Gaylord, Michigan, 49735. Phone number 989-732-1702. And their website is www.michigan.gov/MDHHS. Assistance for veterans may be available through the National Call Center for Homeless Veterans at 1-877-4AID-VET. That's 1-877-424-3838, or the Department of Veterans Affairs Homeless Veterans homepage, www.va.gov/homeless. MSHDA-HARA contact list, Northeast Michigan Community Service Agency, 2375 Gordon Road, Alpena, Michigan, 49707. Phone number 989-358-4678 or 866-484-7077, extension 278. Their website is housingintake at nemcsa.org. Their hours are 8:30 a.m. to 4:30 p.m. Monday through Friday. Reaching an agreement outside of court. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You can find a program at courts.mi.gov/CDRP. Community Mediation Services is located at 114 East Main Street, number 1, in Gaylord, Michigan, 49735. Their phone number is 989-732-1576. And the website is www.mimediation.com. Conditional dismissal. You may be able to reach an agreement with the landlord that will mean your case will get dismissed. The court must provide you with that form for this or tell you where to find it online. It can be found online at www.courts.michigan.gov, and that is Form DC 508.
All right, first case on the landlord-tenant docket is 608 WM LLC versus Jade Kilborn. It's file 26-42487-LT. Who do we have present for that matter, please?
Good afternoon, Your Honor. Adam Cross on behalf of the plaintiff.
Jade Kilborn here on the defense.
All right, I do see Ms. Kilborn is present. This is the first hearing for the parties. Have the parties tried to talk and resolve this matter?
We have not had an opportunity to speak, Your Honor.
Ms. Kilborn, would you be willing to do that?
Yes, Your Honor. I would like to make a statement that I have paid all the past owed amount. And then on the 7th, the August rent would be paid. So there's a zero outstanding balance at this time.
Excellent. Sounds like there should be a quick talking with the attorney and let him have a chance to resolve, to check on that. What I'm going to do is put you both in a breakout room where you can talk privately about this matter. Nobody else will be able to listen in. Once you're done with that, you'll automatically come back into the courtroom and you can tell me what agreement, if any, you've reached. If you've not reached an agreement, we'll simply schedule the matter for additional action to try to resolve it in the future. So we'll put you on that process and I'll call you back as soon as I see you back in the courtroom.
Thank you, Your Honor.
Next matter is Olivia Smith and Eric Garrison, file 26-42437-LT. Who do we have present for that matter, please?
This is Olivia Smith present.
Thank you.
Yes.
Eric Garrison present. Eric Garrison present.
Yep, I thank you very much. I do see Mr. Garrison present as well. Have the parties had a chance to try to resolve this matter?
Nope, he has not paid anything to us at all.
Have you spoken about how to resolve this or not?
No, we are doing a money judgment and possession of property.
You're just trying to get him out, is that correct?
Yes, yes, that is correct.
All right. Mr. Garrison, I believe my notes indicate last time you were here back in July, you were wanting some time to get an attorney. Have you gotten an attorney?
I was not able to retain one. However, I did submit a motion to the court on Friday the 1st, and I tried to get that over to Ms. Smith, but her office manager had stated she was supposed to be out of town until Monday or Tuesday. So I mailed it, but I have not. I just got home to make this Zoom hearing, and then I plan to take up to the court so I could file the proof of service. But I did want to state she's asking for me out. I have a moving truck coming tomorrow. I'm planning to be out of here inside of 48 hours. I'm not sure if the court seen my motion. There was a tentative date that was put in there.
I have not seen your motion because my staff indicates there was no, I'm sorry, Mr. Garrison, I've not seen your motion because my staff indicates there was not a filing fee paid.
Your Honor, I'm not trying to defer from that payment, but I asked the clerk because I said I've never filed something like this before. I don't know what to do. I handed him the 3 copies. The gentleman took the 1 copy and filed it away. And all he told me I had to do from there was go and service the other copy, bring back the proof of service. I was not aware of any filing fee that needed to be applied, sir. I would absolutely take care of that.
I'm having a little trouble hearing what you're saying. So I heard you say that.
I'll repeat
I can repeat
myself, Your Honor. I didn't realize my finger was covering the speaker. I didn't realize that. I came up on Friday around, I think it was around noon-ish, and I talked to the gentleman at your front desk, and I had told him that I've never filed anything with the court before. I don't know how this process works. I handed him the 3 copies that I knew I had to have. He retained the 1 copy and said it was going to the court file and it was being stamped. He handed me back the other 2 copies and stated that I had to service the 1 copy and then bring back the proof of service. But I never was told anything about a filing fee, Your Honor, or I would have absolutely taken care of that on the spot.
All right, and I'm not disputing anything that you're saying. I just don't have it in front of me and I haven't read it because my staff who normally takes care of that was not the one that you talked to. And so he was covering for somebody else at the moment that you were there. So through no fault of your own, you weren't able to get all of the information that should have been given to you. So let's try to see if we have an understanding of where we go from here. It sounds like you're intending to leave the premises. Is that correct?
Yes, Your Honor.
So that, Ms. Smith, that takes care of part of what you're looking for. Is that correct?
Yes, correct.
All right. Ms. Smith would be entitled to, after you leave, go back into the place and see if there are any damages or any other information available to her from that to determine whether or not there's anything else owed. And then she's always entitled to ask for any back rent that has not been paid. Ms. Smith, what is your claim for back rent and for costs of this court case?
So as far as the back rent goes, that's May, June, and July. So it would be 1828. I believe it's $2,700 for those 3 months for May, June, and July at $900 each month. Plus, I believe the court fees was $130 plus the $89.84, which was from the sheriff's department to deliver the last paperwork to them.
All right, I see.
I would be
Was
happy
that-
with the $2,700 for the 3 months back rent.
All right. So, Mr. Garrison, do you have an objection to that? She's basically taking off any court costs that would have been associated with the case and just asking you to pay back or pay for the rent for the time that you were there.
Yes, I understand, Your Honor. I'm from here, like you said, it's being accommodated. The other half, I would like the time for this, I guess, this paperwork to go through and go after the money that way, because my filings have absolute solution to those circumstances.
All right. I'm sorry, I have to stop you, Mr. Garrison. Mr. Garrison, I have to stop you because I'm having a really hard time. I'm only getting about half of what you're saying. It's kind of garbled. Is there a place that you can move to that maybe has a little better connection?
Yeah, it's possibly my connection. Let me step outside, Your Honor.
Thank you.
You're welcome. I said, yes, I do want to object that being the filings that I had filed, although incorrect, as I'm learning, they speak directly to the finances regarding this case.
So what is it that you're objecting to?
Your Honor, I'm not really sure I know how to answer that without referring directly to my filings.
Well, you can tell me. I don't have to look at the pieces of paper. You're entitled to tell me what your objection is, even though you didn't file it in writing. So it's.
I guess I don't know if you can answer this, Your Honor. I'm trying to work with this. May I at least, I guess from that, do I read the summary disposition to you and that would be my objection?
I don't know what you're going to read to me, so I can't answer that question.
Okay. I am objecting because of MCR 2.116 C8 and MCR 2.116 C10. I respectfully move to dismiss the case as follows. Defendant is entitled to summary disposition under MCR 2116 C8, failure to state a claim because plaintiffs failed to attach a valid executed written lease under MCR 2.113 Section C, instead attaching an unexecuted draft instrument that fails on its face value to establish contractual terms or rental obligations. Not to mention, under MCL 600-5720 Section 2, an eviction initiated within 90 days of tenant recording.
Hang on, Mr. Garrison, slow down.
Yes, sir.
If you talk any faster, my ears are going to fall off.
I'm sorry, I'm nervous, sir.
Just slow down. All right. So what you tried to file was a motion for summary disposition stating your legal reasons why.
That is correct, Your Honor.
That does have to be filed with the court and a copy sent to Ms. Smith and a hearing date obtained for that. And there is filing fees for that. My question was much more limited as a way of trying to solve the case. You've indicated that you're already moving out which is part of what the plaintiffs have asked for. The other part of what they've asked for is the rent due. So my question was limited. Are you saying that you do not owe the rent, setting aside your legal reasons about maybe her lack of paperwork in her original complaint? Are you saying that you do not owe
I'm
back
saying
rent?
that I have contractual lease, what's the legal term for that? I have roughly 38 pages here filed, numerous claims against my lease being violated, my lease terms, my financial rights, tenant rights, rights, quiet enjoyment, et cetera. It's in the filings. And I guess that's where I'm confused because I was trying to do it the right way and I thought I filed it properly other than the mailing. I just haven't gotten the proof of service back up to the office yet. But that's what I want. I'm 100% arguing against the monies that are due because of legal reasons that offset the filings.
I'm going to give you an opportunity to do that.
Yes, Your Honor.
And so if you wish to do that, I'm going to give you an opportunity to do that. The person that you need to talk to about that is with me in court today. Her name is Ms. Good. So what I want you to do is tomorrow call the court and find a time where you can either talk to her on the phone or come in person and speak to her about what it is that you need to file and what needs to be done as far as filing fees and court dates for that. And then we will have a hearing on your filings. I need to tell you that 38 pages of filings is substantially unusual for a landlord-tenant matter. And it would be difficult for everybody if that's where you're going with this. So I would encourage you to trim it down to those things that you think are the most important. I can't tell you not to file documents, but I'm telling you it's difficult in any business to look at 38 full pages and give it your undivided attention. So
understood.
Hit me with the most important things and we'll take them line by line if we need to.
Your Honor, can I ask a question in the statement you just made, please?
Yep.
When I stated the 38 pages, that's not just, I guess, disposition pages. That also includes the exhibits.
My sentence still stands.
Understood. Understood, Your Honor.
All right. So, Ms. Smith, go ahead.
Yes, Your Honor. So he claims he's going to be out within 48 hours. Can we please have something, a timeline from the courts, so if he's not out, that we can have the sheriff go and get him out?
I'll take the court appointed 10 days. I'm going to be out of here instead of 48. You can check it, but I'll take the court anointed 10 days.
Sometimes when you ask for something, Ms. Smith, you get what you don't want.
Well, no, I understand that, but if he's not out, if he says he's going to be out in 48 hours and he's not out in 48 hours, then what do I do? So if the court, that's what
sorry to talk over you. I haven't given anybody a judgment yet because he's entitled to file his motion for summary disposition or however he wants to phrase it. And I haven't had a hearing on that yet, and he's entitled to do that. However, Mr. Garrison, leaving and then not allowing the owner in to be able to take care of the place is a difficult position to support from a legal standpoint. It sounds.
Your Honor, I'm willing to tell her when I'm out of there, and you know what I mean, and hand over the keys, or at least leave them in the lock for her, or whatever needs to be managed there.
That sounds like a wonderful way to resolve it.
Yeah, I'm willing to communicate on when I'm out.
All right. I would hope that both sides would be trying to resolve this matter, because if either side is simply attempting to push the limits of where they should be, I, as a judge, in my discretion, often use that against the person who's attempting to do that, because it appears to me that they're just playing games, and I won't have games played in court. Have I made myself clear?
Understood, Your Honor.
All right. So it sounds like, Ms. Smith, that Mr. Garrison is going to make an effort to be out in 48 hours. He's then going to notify you of when he actually is out, and you would be at that point entitled to come in and secure the place and begin to look at if there's anything damaged or not damaged or what things look like. And then we'll go from there once he's filed his motion We'll have it set for a court date. We'll come back as to whether or not any dollars are owed over and above what the rent is, and then whether or not the rent is due as well. Do either of you have any questions for now?
I do not.
Your Honor.
All right.
I do
Thank
not,
you
Your
both very much. That's all for today.
Okay, thank
Your
you.
Honor. Have a good day.
Equilibrium Management and Brian Price, file 26-42445-LT.
Good afternoon,
have
Your Honor.
present,
Norman
please?
Woody on behalf of the plaintiff.
Thank you. We have Brian Price with us. Mr. Price, can you hear me?
Yes, I think I got the microphone on now.
All right, thank you very much. Looks like Mr. Price wasn't with us last time, but he is now. Mr. Woody, have you had a chance to speak with Mr. Price to try to resolve this matter?
I have not.
All right, let me put you in a breakout room with Mr. Price. Do you want Ms. Musel with you at that time?
That would be helpful. Yes, please.
All right, so we'll put all three of you in a breakout room together and see if you can resolve this matter.
Awesome. Thank
Mr.
you.
Price, that's a private place where you can talk. If you reach an agreement, we'll come back in and put that on the record. If you don't reach an agreement, we'll come back into the courtroom and we'll make a plan for how to resolve this case in the future. Please feel free to speak openly to Mr. Whitty. I'll see you in just a few minutes. Thank you, sir. Court's going to recall the matter of 608 LLC versus Jade Kilborn, file 26-42487-LT. Were we able to reach any agreements?
Yes, Your Honor. Adam Cross again on behalf of the plaintiff. I spoke with the defendant, and as she stated on the record, all payments have been made, and so there's nothing further. In this case, I'll be filing a dismissal. I guess the one question I'd have, should that be a stipulation signed by both parties, or can we just dismiss it from the plaintiff's end?
Why don't we just do this? Ms. Kilborn, do you have any objection to the attorney signing your name on that dismissal document so that it gets to my office faster?
No, Your Honor, that is absolutely fine by me.
All right, go ahead and do that now, counsel. You've got that on the record to back you up for that, and I'll just simply wait for you to do that, and I'll sign it once it gets here. Thank you both very much for your cooperation and your patience. Have a great day.
Thank you, Your Honor. You as well. Thank you.
Green Meadows and Cassandra Mogsig, file 26-42441-LT. Who do we have present for that matter, please?
Good afternoon, Your Honor. Rania Haddad for the plaintiff.
Thank you. We have Cassandra Mogsig with us. Counsel, have you had any contact from Ms. Mogsig?
I have not, Your Honor.
We don't have her in the waiting room, do we? All right. It appears that Ms. Mogsig is in pro per, and typically what I do is I give them the benefit of the doubt on their first failure to appear. However, if you want to submit a proposed default judgment and if she fails to appear next time, I'd be happy to sign that document once we get to that point. Do you have any questions for me, counsel?
No, Your Honor. We'll go ahead and do that. Thank you.
All right, let me give you a date to come back. Looks like all of my August dates are used up. So the first one I have available next time is September. I have this off on September 7th. You still have September 7th open?
I do not. Oh, no, because I think that's.
Oh, that's the ones that are off. That's right. So September the 14th is the next date that I have available, counsel.
And what time would that be at, Judge?
2:15.
Thank you, Your Honor.
All right, thank you. That's all for today. Sabrina Moore and Joseph Hodgkin, file 26-42521-LT. Who do we have present for that, please? Sabrina Moore and Joseph or Martha Hodgkin. Anybody present for that?
Hi, Marty is here. Martha Hodgkin is here.
All right, can you turn your video on, please?
Not sure how to do this.
You still with us, Ms. Hodgkin? Ms. Hodgkin, are you still here? Sure, we're still with us. Ms. Hodgkin, can you hear me?
I turned it on. I don't see what, it's not working.
All right, Ms. Hodgkin, can you hear me?
Yes.
All right. I do not see Ms. Moore here with us today. Typically what I do is I give people a second chance to come in because sometimes they don't understand what they're supposed to be doing when they don't have an attorney. So what I'm going to do is I'm going to set a second court date. And if Ms. Moore fails to appear again, the case will be dismissed. If she does appear again, then we'll try to resolve the matter. So I'm going to give you another court date and then we'll mail it out to the parties as well. The next date that I have available is September the 14th at 2:15. So you'd be required to call in again, just like you did today on that date. And in the meantime, I would ask you to get a hold of Ms. Moore and try to resolve this matter. Can you do that?
Yeah, we have been in contact and I am trying to get help with all that too.
All right, keep doing that. Keep trying to resolve it. And if you can, that's the fastest way to do it. If not, I'll see you on September the 14th at 2:15.
Thank you so much.
That's all for today. Thank you. All right, I do see that Mr. Gaines and Mr. Bomback are present with us. Gentlemen, the attorney for Equilibrium Management is in a breakout room with another client. So as soon as he gets back and we're done with that case, I'll call one of your cases and we'll move forward. But if you'd be patient and wait until that happens, I'd appreciate it. All right, the court will recall the matter of Equilibrium Management and Brian Price. That's file 26-42445-LT. Was any agreement reached?
Your Honor, I'm pleased to report the parties have agreed to a conditional dismissal in this case. If I can put those terms on the record.
Hang on just a second. Let me make sure that the defendant is back.
Oh.
He is. All right, so looks like the parties reached an agreement. Mr. Whitty, would you go ahead and put that agreement on the record, please?
Pleased to. Thank you, Your Honor. The parties agree that there's rent to retain through the end of August in the amount of $5,240. Court costs in this matter are $237.09. Total amount to retain $5,477.09. The parties have agreed to a payment plan in this case. Paragraph 3 will provide the defendant shall make payments of $900 every 2 weeks commencing August 7th, 2026 and continuing until the balance in paragraph 2 is paid in full. Payments will be applied first to current leases and then to the arrearage until the balance is paid in full. So it'll kind of, sawtooth its way down over time. We did discuss that the case would be dismissed today, so no judgment, no order of eviction. But if he fails to make those payments, we'd have the right to come back to court under paragraph 4B without notice, without further hearing, and the court would automatically enter a judgment order of eviction. Partial payment wouldn't stop that from happening. We reviewed his rights under MCR 4.201J, after which Mr. Price gave me his email address and indicated to me that I had his permission to sign and submit the agreement to his behalf, which I'd like to confirm on the record.
Yeah, that's fine with me. Yeah.
All right. So, Mr. Price, you've heard all that Mr. Whitty has said. Is that your agreement?
Yes.
And you're doing that without anybody promising you anything else or threatening you in any way?
Yes.
So you're doing this of your own free choice and free will, right?
Yes.
You understand that the conditional dismissal means that the case would not come back in front of me unless you failed to make the payments as you've agreed, and then Mr. Whitty and his client would be able to open the case just like it was today. You understand that?
Yep, I understand.
All right. Mr. Whitty, is there anything else that you want to do today on this matter?
Nothing further, Your Honor. Thank you.
Mr. Price, do you have any questions for me?
Nope.
All right, I'll await the documentations, and once the documents are received, I will go ahead and sign those, and that'll be the court's order. Thank you both very much. Appreciate your time.
Thank you.
Whitty, I think we have a couple other cases, so let me call one of those next. This is Equilibrium Management and Ardell Bomback, file 26-42505-LT. Mr. Whitty, your appearance.
Good afternoon, Your Honor. Norman Whitty on behalf of the plaintiff, Equilibrium Management.
All right, Mr. Bomback is present as well. Have the parties tried to talk and resolve this matter?
We have not, Your Honor.
Mr. Bomback, I propose to put you in a breakout room with Mr. Whitty. Is that okay with you?
Yes, sir.
That'll be a private place where you can talk. If you have any questions, you can go ahead and ask him, and he'll attempt to answer them for you. Just realize he's not your attorney. Once you come back, or once you've tried to reach an agreement, if you're successful, you'll come back and we'll put the agreement on the record. If you're not successful, that's fine too, and we'll come back and try to figure out how to resolve this matter after that. We'll put you in a breakout room, and I'll see you in a few minutes. Mr. Whitty, I assume you want Ms. Musil with you as well?
Yes, please, sir.
All right, we'll put you all three of you in a breakout room. We'll see you in a few minutes. 50-50 chance, Mr. Gaines. Sorry, his file was on top.
Thank you, Your Honor.
All right, appears the parties are back. Let me recall the case. This is Equilibrium Management and Ardell Bomback, file 26-42505-LT. Counsel, were you able to reach an agreement?
Your Honor, not yet. I had a conversation with Mr. Bomback. There's a few things up in the air that we need to resolve, a little bit of homework to do. So I gave him my email address. We're going to continue talking, and I think that we should just set this for a second hearing. I think we could do it by Zoom. I don't think we're sitting here with a big factual dispute where we're going to need to put on proofs.
Is that okay with you, Mr. Bomback?
Second hearing, yes, sir.
All right. The next date that I have available isn't until September the 14th. So we'll set it for then. That'll give you a little bit of time between now and then to hopefully discuss things with each other and exchange documents or whatever else needs to be done. So that'll be 9/14 at 2:15. That will be via Zoom again, just like today. Any questions that you have, Mr. Bombeck?
No, Your Honor, thank you.
Anything further on this matter, Mr. Whitty?
Yeah, I just want to tell Mr. Bombeck that because we're now going into September, September's rent will be added to the balance.
Yeah, of course. Yes, sir.
I just want to make sure you understood that, because I don't want you to come and be surprised.
I understand.
Thank you, Your Honor.
All right. Let me just say it also, Mr. Bombeck, I did get your fee waiver request on the jury trial. And I'm simply going to postpone that until such time as if we need it. If we need it, then I'll make a decision on that. But there's no sense me making a decision today that doesn't need to be made if you guys are going to try to reach an agreement. So we'll simply let that go. Once we've gotten to a place where you can't reach an agreement, if that ever happens, then I'll make that decision, sir.
All right.
All right. Thank you very much. That's all for today then.
Thank you.
Thank you.
All right, Mr. Whitty, we've got another one in just a minute. Let me get my notes done and then we'll call that one as well.
Thank you.
All right, the next matter is equilibrium management and looks like Darwin Gaines. That's file 26-42502-LT. If I could have the appearances of counsel.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Equilibrium Management.
Thank you. And I do see Mr. Gaines is with us. Have the parties had a chance to resolve this matter?
We have not, Your Honor.
All right. Mr. Gaines, similar to the other parties, I'm going to put you in a breakout room with Mr. Whitty, see if you can reach an agreement. If you can, we'll come back into court and put that on the record. If you can't, we'll set out a strategy for resolving that matter in the future. Do you have any questions for me, Mr. Gaines?
No, I don't, Your Honor.
All right. We'll put all the parties, including Ms. Musel, in the breakout room, and I'll talk to you when you get back.
Thank you, Your Honor.
Some odd reason I keep running out of ink.
I try to use one pen until it goes out. It takes me about 6 weeks.
No, I don't have that problem. I had refills. I brought it in from when I was in private practice. I like these kind of pens too. So I don't know why I still had a refill case, but I did. So I brought it in. So I use it up now. So next time I do it, I'll go upstairs and get my pens on the desk. And maybe I'll bring one down here just in case. And I might use it on a temporary basis. But
It's not the same.
yeah,
You have your favorite pen.
yes. My family and some of my colleagues, when I was in prosecutor's office or private practice, used to buy me these really fancy pens. I never used them yet.
They're heavy.
Yeah. Well, I mean, some of them were kind of nice. They were nice. They were very nice pens. I mean, to stick in your pocket, but then you stick it in your pocket and put them on your head.
Yeah. It pulls on your shirt. For sure.
So it's like, yeah, this has got a nice rubber thing where my hand fits, and it's got a nice, not a fine tip, but it's a pretty fine tip. So I can write small if I need to. I kind of like blue with this flow. So
I like it when it's like a soft. I hate it when it's scratchy.
yeah.
Like these, I feel like are scratchy. Although these ones, when you have a lot of paper, if they're the right through ones, it digs.
Yes.
Nice. So
Yes.
it goes through all of them.
My problem with that one is you got to put the cap on the end and it keeps falling off because I'm constantly doing this kind of stuff, and then I don't have it and I can't put it in my pocket then. And so I just have lots of problems.
Bond condition hearings, especially those involving no contact orders, are taken very seriously by the court. These conditions are put in place to maintain the integrity of the case and to prevent any interference with the legal process. When violations are alleged, judges will closely examine communication, behavior, and prior warnings before deciding whether stricter conditions are necessary. If you enjoy clear breakdowns of real courtroom proceedings explained in simple terms, be sure to subscribe to the channel so you don't miss future cases.